At 10:02 a.m., the legal wall collapsed. There was no siren, no dramatic music, no breaking glass. Just a quiet release from the Supreme Court of the United States, 6 votes to 3, and with it, the most ambitious expansion of executive economic power in modern American history cracked in plain sight. The decision did not merely strike down a policy, it exposed the architecture behind it. And within minutes, Washington understood something irreversible had happened. This was not another procedural skirmish. This was a structural failure. The ruling came in a case that had been building tension for months, a direct challenge to the president's sweeping use of emergency authority to impose tariffs without congressional approval. For over a year, that authority had functioned as the steel frame of his trade strategy. It allowed unilateral action. It allowed speed. It allowed unpredictability. And unpredictability was leverage, until it wasn't. The court's majority opinion, written with deliberate restraint, did not attack the policy's wisdom. It did something far more consequential. It questioned its legality. 6 justices agreed that the statute being used, a 1977 emergency law, did not authorize what the president claimed it authorized. And in one sentence that will be quoted in constitutional law classrooms for decades, the Chief Justice wrote, "Those words cannot bear such weight." That line was not rhetorical, it was surgical. The administration had argued that 2 words buried inside the statute, regulate importation, gave the executive branch independent authority to impose tariffs of any size, on any product, from any country, for any duration, once a national emergency was declared. The court disagreed. Firmly. The power to tax, the majority explained, belongs to Congress. It always has. It is written in Article 1 of the Constitution, and while Congress may delegate certain authorities, it must do so clearly. Vague language cannot carry enormous constitutional power. Those words cannot bear such weight. The vote was 6 to 3. That number matters. But what mattered more was who made up the 6. 2 of the justices in the majority were appointed by the president himself. 2 votes that many assumed would protect executive flexibility instead joined the constitutional limit. That is what transformed this from a policy defeat into something deeper. Because emergency docket victories are one thing, full merits rulings are another. Over the past year, the administration had won repeatedly on the emergency docket: temporary stays, procedural approvals, rapid decisions issued without full briefing or oral argument. Those wins created momentum, they created the impression of judicial alignment, but emergency orders are not final judgments. They are pauses, they are placeholders. This case was different. This was full briefing, full oral argument, full opinion, and the court said no. That is why the legal wall collapsed at 10:02 a.m. Because the wall had been built partly on perception, on the belief that executive power would be interpreted expansively, that statutory ambiguity would be resolved in favor of urgency. Instead, the court applied restraint. It invoked constitutional structure. It reminded the presidency that emergency does not erase separation of powers. And that reminder created the first real boundary of this term. The majority did not question whether tariffs were good or bad. It did not weigh economic outcomes. It did not speculate about trade strategy. It read the statute. It read the Constitution. And it concluded that the claimed authority simply was not there. That distinction is critical, because when courts disagree with policy, it is political. When courts reject authority, it is constitutional. This was constitutional. The dissent warned that limiting executive flexibility could weaken national response to foreign threats, but the majority responded implicitly. Flexibility cannot mean infinity, authority cannot mean assumption, and emergency cannot mean exemption from Article 1. Inside the White House, the reaction was swift and sharp. Publicly, the ruling was called deeply disappointing. Privately, officials recognized what it signaled. The judiciary had drawn a line. A real one. Not a procedural delay. Not a temporary block. A boundary. And boundaries change calculations. Markets recalibrate. Lawmakers reconsider. Allies reassess. Because if one emergency power can be reinterpreted downward, others might be too. That is the deeper tremor beneath the headline. The legal wall was not just tariffs. It was a broader theory of executive reach. And when one supporting beam fractures, pressure shifts across the entire structure. The question now is not simply what happens to the tariffs. It is what happens to the architecture built around them. Because when a court says those words cannot bear such weight, it is not just interpreting a statute, it is redistributing power. And redistribution is rarely contained to one case. At 10:02 a.m., the legal wall collapsed. What falls next may define the rest of the presidency. Before the ruling, before the 6-3 vote, before the sentence that would echo through constitutional law, those words cannot bear such weight, there was a structure, a carefully layered structure. What looked from the outside like confidence was, in reality, architecture. The legal wall was not built in a single motion. It was constructed brick by brick, doctrine by doctrine, strategy by strategy, each layer reinforcing the next. And for a time, it worked. The first layer was presidential immunity. In July 2024, the Supreme Court recognized broad immunity protections for presidents performing official acts. The ruling did not declare presidents untouchable, but it significantly narrowed the scope of what prosecutors could pursue while a president remained in office. That doctrine became the outer shield. It established a presumption: official acts are insulated. That single principle created legal ambiguity powerful enough to stall cases, delay proceedings, and complicate accountability. It did not eliminate exposure, but it slowed it. And in law, delay can be as valuable as victory. The second layer was emergency powers. The administration's reliance on a 1977 statute to justify sweeping tariffs was not accidental. Emergency authority provides speed. It provides unilateral control. It bypasses congressional gridlock. By declaring a national emergency, the executive branch unlocked regulatory tools that previous administrations had used cautiously. But this time, the interpretation expanded dramatically. The claim was not that emergency law allowed limited restrictions. The claim was that it allowed taxation-level economic power. That expansion transformed a statutory tool into a structural pillar. It allowed one office to move markets, redefine trade relationships, and generate billions in revenue without fresh legislative approval. For over a year, that interpretation held. The third layer was Department of Justice policy. Long-standing DOJ guidance maintains that a sitting president cannot be indicted. That policy is not a constitutional amendment. It is internal doctrine. But it carries immense practical weight. Federal prosecutors operate within it. Courts defer to it, and it effectively postpones federal criminal exposure until after a presidency ends. That delay shifts timelines. It changes leverage. It allows legal battles to stretch beyond election cycles. Combined with immunity doctrine, DOJ policy created a powerful buffer against immediate federal consequences. The fourth layer was the pardon power. Article 2 of the Constitution grants presidents authority to pardon federal offenses. Used traditionally, it is a tool of mercy. Expanded strategically, it becomes something else. Broad clemency decisions signaled to allies and associates that federal consequences could be mitigated. Pardons do not erase state convictions, but they reshape federal risk calculations. They reinforce loyalty. They alter incentives. And they send a message. Proximity to executive power carries protection. That message, whether explicit or implicit, becomes its own form of reinforcement. The fifth layer was forum strategy. Legal teams do not merely argue cases, they choose venues. Moving litigation between jurisdictions, appealing unfavorable rulings, seeking federal review of state matters. These are tactical maneuvers embedded in the system itself. Forum selection can influence pace, precedent, and procedural advantage. It can stretch cases across years. It can reposition arguments before different judges. None of it is illegal. All of it is strategic. And when combined with delay-oriented doctrines, it strengthens the wall. The sixth layer was political pressure, public criticism of judges, aggressive rhetoric, framing unfavorable rulings as partisan, highlighting judicial identities. None of this changes a statute, but it changes atmosphere. It raises stakes. It amplifies tension. And it creates a climate in which institutional actors operate under scrutiny and, sometimes, threat. Pressure does not always alter outcomes, but it alters context, and context matters. Each of these layers on its own is defensible within the American legal framework. Immunity doctrine has precedent. Emergency statutes exist for crises. DOJ policy predates this administration. Pardons are constitutional. Venue strategy is routine. Political speech is protected. But together, they form something larger, a reinforcing system designed to absorb shocks. A legal wall. If one case faltered, another doctrine delayed it. If one court resisted, another venue could be sought. If one investigation advanced, policy postponed it. It was not a single shield. It was a network. And networks are resilient until a central beam fails. The Supreme Court's 6-3 ruling did not dismantle all 6 layers. It did something subtler and more dangerous. It rejected the expansion principle at the heart of the structure. It declared that vague statutory language cannot justify sweeping constitutional power. That declaration does not apply only to tariffs. It applies conceptually to any argument built on broad inference. The court did not merely remove one brick. It tested the foundation. And foundations, once questioned, invite inspection everywhere else. because when executive authority is reinterpreted downward in one arena, litigants test it in others. When judicial deference tightens in one case, it signals scrutiny ahead. The ruling exposed something the emergency docket victories had concealed. Full merits review is different. It is slower, it is deeper, and it is less forgiving. The legal wall had survived procedural skirmishes. It did not survive structural examination. That is why the 6-3 vote reverberated beyond tariffs. It suggested that the judiciary would not simply process executive arguments, it would weigh them, and weighing changes outcomes. The architecture remains partially intact. Immunity doctrine still exists. DOJ policy still stands. Pardons still operate. Strategies remain. But the assumption that statutory ambiguity would always bend toward executive expansion has been shaken, and when assumption shifts, strategy must shift with it. The wall did not collapse because one doctrine vanished. It cracked because the belief sustaining all 6 layers was tested and found limited. Because when one wall cracks, pressure shifts everywhere. The difference between an emergency order and a merits ruling is the difference between a warning shot and a final verdict. For more than a year, the administration had survived on warning shots, temporary stays, procedural victories, quick unsigned orders issued on what legal scholars call the shadow docket. Those rulings allowed policies to move forward while litigation continued below. They created momentum, they created headlines, they created the impression of durability, but they did not answer the constitutional question. This case did, and that is why the 6-3 vote changed the presidency. Because this was not an emergency application decided in hours, this was full briefing, full oral argument, a written opinion that will sit permanently in the United States reports. This was the court speaking at full volume, and what it said was narrow, precise, and devastating. The administration had argued that a 1977 emergency statute granted the president authority to impose sweeping tariffs once a national emergency was declared. The statutory language allowed the executive to regulate importation. From those 2 words, separated by several others, the government claimed independent power to tax imports from any country, at any rate, for any duration. The majority did not dispute that emergencies exist. It did not deny that presidents require tools to respond to foreign threats. It asked a more fundamental question. Did Congress clearly grant this specific authority? The answer was no. And that answer was grounded in a doctrine built largely by the conservative legal movement itself, the Major Questions Doctrine. The Major Questions Doctrine holds that when an executive agency claims power over an issue of vast economic and political significance, Congress must have spoken clearly. Ambiguity is not enough. In recent years, the doctrine had been used to limit regulatory expansions under different administrations. It was applied in cases involving environmental rules and student loan forgiveness. It was designed to prevent executive overreach through vague statutory interpretation, and now it was being applied here. The irony was unmistakable. The intellectual framework that constrained prior presidents was now constraining this one. Chief Justice John Roberts wrote the majority opinion. His language was measured. He did not accuse. He did not editorialize. He read the statute. He read Article 1 of the Constitution. Congress shall have the power to lay and collect taxes, duties, imposts, and excises. That power belongs to the legislative branch. It is not incidental. It is foundational. Tariffs are taxes, and taxes require congressional authorization. Roberts wrote that the statutory words relied upon by the administration could not support the weight placed upon them. Those words cannot bear such weight. That line was not stylistic flourish. It was structural reasoning. If 2 vague words could authorize unlimited tariff authority, then the separation of powers would become optional. The court refused that expansion. Justices Neil Gorsuch and Amy Coney Barrett, both appointed by the president, joined the majority and wrote concurring opinions reinforcing the reasoning. Gorsuch emphasized constitutional structure, that liberty depends on clear lines of authority. Barrett focused on textual clarity, that statutory interpretation must be grounded in what Congress actually enacted, not what the executive wishes it had enacted. Their concurrences were not symbolic. They signaled agreement with the principle that executive authority must remain bounded by explicit legislative language. The dissent, written by Justice Brett Kavanaugh and joined by Justices Clarence Thomas and Samuel Alito, warned that the majority's approach constrained necessary flexibility in foreign affairs. The dissent argued that historical practice supported broader interpretation of emergency economic powers. But even in dissent, the debate was framed around statutory meaning and constitutional allocation, not political preference. That distinction matters. Because what happened in this ruling echoes a historic moment from 1952. In Youngstown Sheet and Tube Co. v. Sawyer, The Supreme Court rejected President Truman's attempt to seize steel mills during the Korean War. Truman argued that wartime necessity justified executive action. The court disagreed. It held that the president could not seize private property without congressional authorization. That case became the defining boundary of executive emergency power. This ruling carries similar resonance. It does not question the existence of threats. It questions unilateral authority. The comparison is not rhetorical, it is structural. In both moments, the court confronted an executive branch asserting expansive power in the name of urgency. In both moments, the court responded by pointing to the Constitution, and in both moments, the vote signaled that even presidents supported by a majority of the court are not insulated from constitutional limits. The key theme here is not defiance, it is design. The court was not making trade policy. It was not weighing economic strategy. It was not judging whether tariffs help or harm. It was drawing a line, a constitutional line. It was saying that if Congress wishes to grant sweeping tariff authority, it may do so explicitly. Until then, the executive may not assume it. That is not activism. It is allocation. It is the separation of powers functioning as intended. The presidency remains powerful. Emergency statutes remain on the books. But this ruling clarified something fundamental. Power must be traceable. It must have a textual anchor. It must be legislatively conferred. Without that anchor, it does not stand. This was not rebellion. It was separation of powers working. The constitutional argument was precise. The vote was historic. But the real shockwave was not philosophical. It was financial. Because behind the legal theory, behind the statutory interpretation, behind the sentence that those words cannot bear such weight, there is a number, $175 billion. That is the estimated amount collected under the tariff authority the Supreme Court just declared unauthorized. $175 billion paid not by foreign governments, not by rival powers, but by American importers when goods cross the border. Manufacturers, retailers, agricultural distributors, small businesses that wired money to Customs and Border Protection under rules that, as of this ruling, never legally existed. For more than a year, those tariffs functioned as operational reality. Containers arrived at ports, duties were calculated, payments were processed, costs were absorbed or passed along, supply chains adjusted, contracts were rewritten, consumers saw prices change, entire industries reorganized around rates that could shift overnight, and now the legal foundation under those payments has been removed. The Supreme Court invalidated the authority, but it did not answer the most explosive question: what happens to the money? Refunds are not automatic. The opinion struck down the power going forward. It did not prescribe restitution. That silence is where the tension lives. Because if courts ultimately require the government to return funds collected without authorization, the repayment would be unprecedented. It would be the largest mass refund in federal history. Treasury would face immediate budget pressure. Revenue projections would be disrupted. Deficit calculations would shift. And Congress would be forced to respond. If refunds are denied, the opposite problem emerges. The government retains money collected under authority the court says did not exist. That scenario would ignite its own wave of litigation. Either outcome carries consequence. The uncertainty itself is destabilizing. Markets do not fear losses alone. They fear ambiguity. In the days following the ruling, financial analysts began recalculating exposure. Companies that had paid millions in tariffs quietly consulted counsel. Accounting departments reviewed filings. Investors tried to determine whether refund claims would be recognized as assets or dismissed as wishful thinking. Treasury bonds, sensitive to fiscal stability, reacted to the unknown. The question was no longer simply about trade policy. It was about legal reliability. Small businesses felt the strain first. A mid-sized importer that paid $10 million in tariffs over the past year must now decide whether to initiate a refund claim. That process could take years. It could require additional litigation costs. It could depend on further court interpretation. Meanwhile, payroll must be met, inventory must be financed. The ruling provided clarity on authority, but not on compensation. For some companies, the difference between reimbursement and denial is the difference between expansion and contraction. That is the scale of the $175 billion question. Investors understand this dynamic intuitively. Markets can absorb bad news. They can price in losses. They can adjust to higher taxes or lower profits. What they struggle to price is instability in the rules themselves. This is where Warren Buffett's perspective becomes instructive. Buffett has long argued that markets function best when the rules are clear, even if the rules are imperfect. Uncertainty about authority distorts long-term planning. When tariff rates changed without warning, when executive interpretation stretched statutory language to its limit, capital hesitated, projects were paused, hiring slowed, Supply chains diversified not for efficiency, but for protection. The unpredictability became its own tax. Before the ruling, the environment was fluid. Rates could rise by executive order, exemptions could disappear, negotiations could reverse. Companies could not reliably forecast 6 months ahead. That environment rewarded short-term maneuvering and punished long-term investment. After the ruling, something shifted. The court restored a boundary. It reaffirmed that taxing authority rests with Congress unless explicitly delegated. That principle does not eliminate tariffs. It clarifies their origin. It recenters authority within the legislative process. Investors prefer that clarity, even if it produces policy battles. Stability does not mean comfort. It means predictability. Yet, clarity on authority does not resolve the fiscal reckoning. The collected funds remain in federal accounts. Budget planners must account for potential repayment risk. Businesses must decide whether to pursue litigation. Shareholders must evaluate contingent assets. The Treasury must prepare for multiple outcomes. The immediate constitutional crisis has been settled. The financial aftershock continues. Because $175 billion is not theoretical, it represents capital already moved, margins already adjusted, consumers already charged. The ruling may have restored structural order, but it did not erase the ledger. Markets exhaled at the restoration of a constitutional boundary. But accountants opened new spreadsheets. Stability returned. But the bill remains. The legal decision landed at 10:02 a.m. The political explosion began minutes later. The ruling was framed by the court as constitutional restraint, but inside the White House it was received as confrontation. The president read the summary, paused, and delivered a blunt assessment. Deeply disappointing. Within hours the tone escalated. He described members of the majority as misguided. He suggested the court had failed to understand the stakes. And when pressed about the two justices he himself had appointed who joined the 6-3 majority, his response carried unmistakable edge. He called their decision shameful. He questioned their courage. It was not just disagreement, it was personal. That shift matters because rhetoric reshapes pressure. Criticism of judicial reasoning is common. Casting doubt on judicial loyalty is something else. The language signaled to supporters that this was not merely a legal setback, it was a political struggle. And political struggles demand response. The response came quickly. Before the news cycle could settle, a new executive order was drafted. If one statute would not sustain the tariffs, another would. Within hours, the president signed an order invoking Section 122 of the Trade Act of 1974, a different legal pathway, a narrower one. The new tariffs were set initially at 10%, then raised to 15% the following day, the statutory maximum allowed without further congressional approval. It was decisive. It was immediate. It was calculated to demonstrate momentum rather than retreat. But Section 122 carries constraints that the prior emergency interpretation did not. It contains a ceiling 15%. It contains a clock 150 days. After that, congressional authorization is required to extend it. That clock is not symbolic. It is binding. It transforms unilateral executive action into temporary leverage. It forces legislative engagement. It invites political negotiation. The administration framed the move as continuity. Critics framed it as circumvention. The core question began to circulate in Washington: compliance or defiance? On its face, invoking an existing statute is compliance. The president accepted the court's interpretation of the emergency law and pivoted to another authority granted by Congress. But the speed of the pivot and the escalation in rhetoric fueled suspicion that the underlying objective, maintain tariff pressure at all costs, had not changed. The difference now was that the legal lane was narrower, and narrower lanes concentrate traffic. Congress suddenly held leverage. Lawmakers who had previously avoided direct votes on tariff strategy now faced a looming deadline. If the 150-day clock expires without action, the tariffs lapse automatically. That reality reshapes alliances. Business groups began contacting Senate offices. Agricultural exporters demanded clarity. Manufacturing associations sought assurances. Members of Congress who had remained quiet found themselves fielding urgent calls. Political gravity shifted from the White House to Capitol Hill, and as it did, the tone evolved. 4 days after the ruling, during the State of the Union address, the language softened. Gone were the sharper accusations. In their place was measured disappointment. The ruling was described as unfortunate. The administration emphasized resilience. The justices in attendance were greeted with formality. The shift was subtle but visible. Public fury gave way to calculated posture. That change suggests strategic recalibration, because political backlash must be managed as carefully as legal argument. Investors were watching, allies were watching, Congress was watching. markets respond to volatility, and volatility now extended beyond trade policy into institutional tone. Section 122 provided temporary ground, but temporary ground is not permanent authority. The 150-day clock ticks toward a deadline that intersects with electoral timelines and budget negotiations. If Congress extends the tariffs, it shares ownership. If it declines, the policy expires. Either path requires votes. Either path distributes accountability. That is the structural change the ruling forced. What once operated under executive interpretation now demands legislative participation. The legal wall that insulated tariff strategy has fallen. In its place stands a contested political arena, and that arena is volatile. Because rhetoric can escalate faster than statutes. Because deadlines concentrate pressure. Because compliance and defiance are not always clear opposites. Sometimes they coexist in strategy. The administration complied with the ruling by shifting statutes. It defied the spirit of limitation by preserving the objective through alternative authority. That duality will define the coming months. The markets have recalibrated to constitutional boundaries. Congress has regained leverage. The White House has retained initiative for now, but initiative constrained by a clock is different from initiative without limit. And clocks run out. The legal wall may have fallen, but the political fight just began. The ruling settled the tariff question. It did not settle the future, because when a constitutional boundary is redrawn in public view, the immediate case is only the beginning. The deeper question is what collapses next. This decision was not about trade alone. It was about executive reach. It was about how far emergency authority can stretch before it snaps. And now that the court has clarified one limit, every other expansive interpretation of executive power will be examined through the same lens. For future presidents, the message is unmistakable. Emergency statutes are not blank checks. Vague phrases cannot carry enormous constitutional weight. If Congress intends to delegate sweeping authority, it must do so explicitly. If it does not, the judiciary will not infer it. That principle narrows the playing field for every administration that follows, regardless of party. Because the doctrine applied here, the major questions, doctrine, textual restraint, structural separation does not belong to one ideology. It belongs to the court's understanding of constitutional design, and that design outlives individual presidencies. The limits of emergency authority have now been tested in a high-stakes environment. For decades, emergency declarations expanded incrementally. Presidents invoked them for sanctions, asset freezes, regulatory adjustments. Rarely did those declarations trigger direct confrontation over taxing power. This case forced that confrontation. It clarified that urgency does not erase Article 1. It reminded the executive branch that Congress retains primary control over revenue generation. That clarification will shape internal White House legal reviews for years. Future counsel will hesitate before stretching statutory text, because precedent now exists, and precedent constrains ambition. The ruling also redefined the judiciary's role in moments of political imbalance. When Congress struggles to assert itself, when polarization paralyzes legislative oversight, the courts become the venue of last resort. That is not ideal in theory. The Constitution envisions balance across three branches. But when one branch expands and another hesitates, the third must interpret. This case demonstrated that interpretation can still draw hard lines. It signaled that institutional survival does not require dramatic gestures. It requires adherence to text. The system has been under pressure. Political rhetoric has intensified. Public trust has fluctuated. Judges have faced criticism. Agencies have navigated uncertainty. Yet when confronted with a direct constitutional question, 6 justices, including 2 appointed by the president whose power was being limited, affirmed structural boundaries. That is not collapse. That is endurance. The metaphor of the wall matters here. The legal wall was not destroyed by a single strike from opponents. It was not dismantled by electoral defeat. It was not breached by sudden scandal. It collapsed because it was over-leveraged. It depended on broad interpretation layered across multiple doctrines. It relied on ambiguity, expanding in one direction. When the court withdrew that expansion in a single case, the leverage redistributed. The structure could not hold its previous shape. Over-leverage is a familiar concept in finance. Companies can operate with aggressive assumptions for years. They can grow rapidly. They can appear invincible. But when one foundational assumption proves false, markets reassess everything. That reassessment is rarely immediate collapse. It is recalibration. The same dynamic applies to constitutional power. When one expansive theory is rejected, others must adjust. Executive authority remains formidable. The presidency remains the most visible office in the nation, but it now operates within a reaffirmed boundary, and boundaries influence behavior. Legislators may assert themselves more forcefully on tariff policy. Agencies may draft regulations more cautiously. Future presidents may consult Congress earlier rather than later. These are incremental shifts. But incremental shifts compound. What collapses next depends on response. If the executive embraces the boundary, the system stabilizes. If it searches for alternative expansions, new litigation will follow. The Constitution does not enforce itself automatically. It relies on institutions and individuals to respect its structure. This ruling demonstrated that the structure still functions when tested. It did not shout, it did not grandstand, it did not frame itself as revolution. It cited Article 1, it applied doctrine, it rendered judgment. In moments of high political tension, restraint can feel anticlimactic. But restraint is precisely how constitutional systems endure. The presidency will continue. Tariffs may return under different statutory frameworks. Political battles will intensify. Elections will reshape priorities, but the boundary drawn here will remain. It will sit in law books. It will be cited in future arguments. It will limit future claims. The wall was never invincible. It appeared strong because it had not yet faced full structural review. Once reviewed, its leverage became visible. And once visible, it could not sustain its own weight. In the end, the Constitution did not shout. It simply stood where it has always stood, and the wall built against it gave way. This wasn't just a ruling, it was a boundary.